afternoon, everyone. I'm Tricia Balia. I'm a professor here at the law school, and I'm very grateful to have the opportunity to moderate a panel in the symposium, which to my mind has gone really fabulously well, and the papers are great, and I know that we'll just continue this afternoon having great conversation. So I feel like our panel here, historical backdrop, I want to put a colon on it from what I've seen so far, is like historical backdrop and the way forward. So I don't know if that's going to hold all the way across the panel, but at least that's my thought going in. And so we have three panelists again, Professor Emily Bremer, whom you all know, who organized us here and is professor at Notre Dame. And then Evan Bernick, Northern Illinois University College of Law, and then Noah Rosenblum from New York University School of Law. And thank you all for being here, for your travels and whatnot. I was asked to make one announcement about, we're gonna end perfectly on time, both because that's my OCD, but also because I know there are people who have to get to the airport, and there are two cars that are gonna be right at the circle to take those of you who have the flights. We'll be right out at the circle, right out the door. I know there's a couple tight ones, so we'll get underway. So we're going to start with Professor Bremer.
Great, thank you. So yeah, this has just been so wonderful. This is like my dream conference, and I just want to thank the law review again for letting me get away with this. So I'm gonna speak a little bit about. Basically, I'm going to give you several propositions that have emerged out of my work on the APA's history over the last several years. And these, I wrote a paper at this point about a decade ago arguing that administrative law is an unwritten constitution and identifying the APA as kind of the super statute backbone of administrative law. And so I came to my work on the APA history with that sort of framing in mind, which of course we've already had some really rich discussion about. And I discovered some surprising things. I wrote one article about the original idea about adjudication. I wrote another article about the original history of the rulemaking provisions of the APA, because I care about what agencies do. So none of that judicial review nonsense, just the procedural provisions of the APA. And I had some thoughts about the implications of this for the APA's characterization as a super statute, and maybe some thoughts about what the lessons might entail for other framework statutes that might be enacted. So I'm going to give you two propositions and a warning. The first proposition is about adjudication. And I spent many years studying adjudication, mainly because other people made me. I originally studied rulemaking like everybody else. And then I got assigned to do something about adjudication, and I got kind of obsessed with it. Because we have a very sort of standard model. There's informal and formal modes of both rulemaking and adjudication. In the adjudication space, what that means to say that there's an informal and a formal mode is that you can have an informal hearing or a formal hearing in adjudication. And so I spent many years trying to figure out what that means, right? Because the APA doesn't really regulate informal adjudication, and as a purely descriptive matter, we've got hundreds of adjudicatory programs across the federal government that are conducted so-called outside the APA. And just trying to figure out why and how, and is that consistent with the statute? And then when I did the research into the background of the APA, I realized that's wrong. Informal and formal adjudication are not alternative modes of the same thing. They're stages, and it's, you do the informal stuff first, investigations, negotiations, inspections, examinations, all that stuff. And usually 95% of the time, you get clear facts that no one disputes that have obvious legal significance, and the agency can issue a final decision and you're done. And it's only if there's a dispute that remains that you elevate it to the hearing stage. And a hearing is formal. Right, so under the APA as originally conceived, there is no such thing as an informal adjudicatory hearing, right? It's informal adjudication that's non-hearing stuff, and then you have when you have to have a hearing and the statute says you have to have a hearing, it's a hearing under the APA. So the conclusion that I have come to now that the APA structure is clearer to me, is that the APA just failed in adjudication. It is a failure, right? It is not a super statute in adjudication. And the interesting question for me is why? I mean, that's the battleground. That's what they were mainly fighting over when the APA was enacted. So how did the one place where we really needed the APA and we really focused all of our attention, how did that fail to achieve the aims of the APA? And I come up with a few reasons. I mean, I think one is that it was a mixture of codification and reform. You had a lot of law already in place, including statutes that told agencies like what to do, and they had filled in the details in quite a bit of quite a bit of crystallized policy and procedure and practice. And the APA was intended to codify some of that, but also reform other bad practices that were identified. And that's a really messy blend, right? Just figuring out which parts of the APA are codification of what agencies are already doing versus reform of things that need to be fixed. That's a difficult task in and of itself. And even once you figure out what the APA is trying to codify and what it's trying to reform, then you have to actually apply that to individual agencies. But Congress tried to reform without making any conforming amendments to existing statutes, which is crazy because our system has a very deeply ingrained principle that we disfavor repeals by implication. And so you have lots of legal room to argue that the APA doesn't force us to change and our statute is still the same, right? Lots of legal room to justify continuing to do what had been done before the APA's adoption. Then you combine that with the most powerful force in government, inertia, right? You had all these agencies that had been doing what they've been doing for years and kept, for the most part, right on doing it. And where the APA was consistent with that, they followed the APA. And where it wasn't, well, they found a reason to explain why, well, their statute didn't change and the APA didn't really require them to change and they kept right on doing what they were doing. So my bottom line is that adjudication, the APA failed. It didn't achieve what it was designed to achieve. The last vestiges are sort of under attack now. I don't like that, but everyone else seems to. So moving on. So what about rulemaking? My view is that the APA succeeded spectacularly in rulemaking, right? I mean, in rulemaking, all agencies that make rules pretty much make them using Section 553 notice and comment rulemaking. It is the standardized procedure that is used to enact legislative rules. And it's uniformly used across the federal government. And that was the point. That's what we wanted from the APA. So it seems like it's been just spectacularly successful. So why, right? Why did rulemaking succeed if the adjudication provisions failed? And a lot of it is exactly the opposite of what I just described in adjudication, right? Agencies were mainly doing adjudication when the APA was enacted. There wasn't that much rulemaking and it was used for very different purposes. And so it just wasn't where the attention was really focused. The statutes that were in existence didn't really say much about rulemaking procedure, and so there wasn't a lot of law to sort of fight against. The agencies, because they didn't do a lot of rulemaking and their statutes didn't have a lot of provisions that they needed to like fill in the details with, like they hadn't really created standardized procedures even within agencies for rulemaking. There was experimentation with external consultation, but the agencies that did that did it on an ad hoc basis. They really hadn't crystallized their procedures. There's a great article right before the APA is enacted that explains how there's a trillion different ways of conducting rulemaking, and you could never standardize this because every agency has what it needs. And so in the place where pre-APA, the sort of framers of the APA thought this isn't a thing you can standardize, well, they did, and they did it successfully. And because of everything I described, a lack of law, and by the way, one thing I didn't mention, due process regulates quasi-judicial action. It doesn't really have much to say about the procedures used in quasi-legislative action. Right? So you also had a body of law on the adjudication side, and you had no similar body of law on the rulemaking side. So in a way, Congress was kind of writing on a blank slate before agencies really needed a framework for making sort of high-level policy decisions through rulemaking. And so at the end of the day, the reason why I think the APA succeeded was a combination of the fact that they didn't need to reform, there wasn't much to reform, and they came up with a framework decades before it was needed, right? They were prescient. Now, of course, I'll pause to note that I've so far said that a framework statute is unlikely to succeed if it's trying to reform known problems, and it's likely to be extremely successful if Congress can be prescient and know what's coming. I don't know how you replicate that success on the rulemaking side. But the last thing I want to end with, and the sort of final proposition, and this is kind of a warning for the future, is that, if there's one thing I've learned in the past several years of doing all this research, it's that an enormous amount of the content, the meaning of the APA, comes not from the text, but from the background assumptions, right? The context from which the APA emerged, the judicial precedent, the agency practice, just the understandings about what administration is and how it operates. And for decades after the APA was enacted, and it's a very brief text, right? All of that background, I think, was well understood by the legal profession. But as it's been lost, and as simultaneously we have a rise of a commitment to textualism, you have the danger of a really shallow textualism that ends up attributing to the APA substantially less meaning than it had when it was enacted, and that ends up giving you the possibility of interpreting the words wrong, right? Using background presumptions that are, in some cases, diametrically opposed to the background assumptions that informed the statute as originally written. And so I think we have to come up with a way to fight against that eroding knowledge, right? Or confront the potential necessity for revising the APA so that the statute conforms to current understandings, background understandings about what administration is and how it ought to operate. And I'll stop there.
Okay, thank you.
So first of all, thank you to the Notre Dame Law Review for inviting me to this really spectacular symposium. You guys deserve all the congratulations in the world for putting this together. I've really enjoyed myself, all of the panels, Justice Kavanaugh, it's all been great. And thank you to Emily for inviting me to participate in it. This paper doesn't play particularly well with others, and I hope that my comments will capture its confrontational spirits. I too have propositions. Proposition the first. Regulatory policymaking in the modern administrative state is dominated by business interests that tend to favor deregulation, of which a particularly vivid illustration is very successful notice and comment rulemaking, the primary mode through which most agencies make regulatory decisions. Studies have shown not only that business commentators have a greater influence than non-business commentators over the content of their rules, but that their influence grows as their proportion increases. Thus, more business comments, more business influence. Most commentators are in fact business commentators, so typically absent from notice and comment rulemaking are most regulatory beneficiaries, state, local, tribal governments, unaffiliated experts, stakeholders with situated knowledge of the regulatory issues that stand to be directly impacted by their resolution, but don't have quite as much at stake in terms of pecuniary gain and aren't as well organized. Now, domination by concentrated interests of the rulemaking process would be a small d democratic problem, even if we didn't at this moment face multiple interrelated crises of economic precarity, systemic racial inequality, and environmental destruction. But we do. So how did we get here, and what do we do about it? Should we take the administrative procedure we have as for the most part settled and work within it, or do we try to transform it? My paper has two goals, and therefore perhaps should be two papers, already way over the word count. One way or the other, however, I am determined to achieve those goals, and I will do my best to succinctly summarize them here. But first, I want to highlight a common theme that it shares with Emily's work, on which it often draws, as well as John and Bill Eskridge's work, which you heard about in the morning, and which I now need to cite and engage with. And that theme is revising APA revisionism. By APA revisionism, I mean to encompass the work of Joanna Grinsinger, Katie Kovacs, George Shepard, Martin Shapiro, and others who have, I think, successfully dispelled at this point a long perpetuated myth about the APA's enactment. And that myth was, with some license for exaggeration, by the time of the APA's enactment, acrimonious New Deal politics had given way to careful deliberation about administrative governance that culminated in a statute that was so perfect that to behold it was to assent to it. Again, exaggerating slightly. The reality, according to the revisionists, is that the APA emerged from a long drawn-out fight over the New Deal that ended only when everyone was exhausted and agreed to agree on a little and disagree about a lot later. I see Emily, John, Bill, and I as revising this revisionism, not rejecting it, but complicating it, drawing out aspects of the APA's formation that aren't adequately reflected in the story that we usually tell about it. Of course, we do so in very different ways, to very different ends. Speaking of those ends, my goals. One is negative, the other is positive. The negative part involves critiquing the now dominant accounts of the APA's origin and content. The positive part involves sketching a substantive approach to administrative procedural reform that is fit, unlike the APA, to meet the crises of our time, which will require administrative actions on a scope and scale that the APA was designed to and does in fact hinder. So why focus on the origins of the APA? Well, the origins of the APA have long been said to tell us important things about how we should understand its contents. For instance, perhaps we should understand it as largely codifying existing agency practice because that's what its drafters said that they were doing. Why we should accept its legitimacy, that's also part of the origin story of the APA. The APA's legitimacy has been tied to its character as a carefully deliberated compromise that is ideologically neutral. Now today there's an increasing amount of left-of-center dissatisfaction with it, mostly because of its lack of perceived neutrality in practice. The most vivid illustration of this being notice and comment rulemaking. Yes, it was defended in the name of democracy. Yes, it represented an improvement upon the status quo from a democratic standpoint. What rulemaking existed before the APA was, as Emily has shown, very sympathetic to regulated interests, very informal, very non-transparent, and very not open to public participation. But in practice, the notice and comment process that we have is not robustly democratic if we think that democracy entails not only merely formal access to a process, but meaningful power to affect its outcome. Returning to the APA's origins provides us with an opportunity to reevaluate the grounds for its legitimacy arguments. To ask questions like, might it in fact be operating in a way that it's designed to? And might the way that it's designed to operate be ideologically not neutral? And if so, shouldn't those who don't share those ideological premises take a rather dim view of it? I argue that the APA is not neutral because it arose from a not neutral ideological consensus. It may have been a compromise between pro and anti-New Dealers, but that doesn't make it neutral. What it meant to be a pro-New Dealer in 1946 was different than what it meant in the early 1940s. By the time the APA was unanimously voted into law, many avowed New Dealers had retreated from or outright repudiated ends and means that had once been central to the New Deal. For example, many New Dealers had abandoned support for corporatist industrial councils in which representatives of labor, capital, and government would cooperate to regulate industrial sectors. Most fundamentally, New Dealers no longer believed that something was fundamentally wrong with capitalism that required the reshaping of its institutions. Those who so much discussed tensions between capitalism and democracy were the subject of coordinated attacks, including by democratic presidents. Administrative reform began in earnest in the late 1930s, at around the same time that FDR was purging leftists from the NLRB because he was battered by anti-communist Republican critics. This was right around the time that the push towards administrative reform began to gather momentum. Pro and anti-New Dealers did, as John argues, agree on fundamental principles. This wasn't a thin consensus, or it wasn't just a thin consensus. These principles were hegemonic, they were common sense. But whereas John focuses on conservatives becoming less anti-administrative, I really focus on liberals becoming more conservative. Interest group pluralism had become the common sense of what democracy meant. So whereas early New Dealers had identified democracy with the collective pursuit of substantive goods in the absence of domination, understood as being at the mercy of arbitrary and unchecked power, be it state or private, interest group pluralism was agnostic about substantive goods and valorized competition between groups, none of which had a greater claim on the state's attention. Anti-communism, which manifested itself in suspicion of administrative redistribution, Lawyers as managers of the administrative state, court-structured, court-supervised administrative justice defined and elaborated by judges. And throughout the period of administrative reform, there existed what Ira Katznelson has called a Southern cage on federal legislation. Southern members of the House and Senate, by way of preserving Jim Crow, worked to ensure that legislation would not disturb it. Not only did they exercise an effective veto on civil rights legislation, they tailored New Deal bills surgically to exclude Black people from their benefits. Okay. All very interesting. What does this have to do with the APA? The APA reflects this deep ideological consensus. Rulemaking and adjudication place all affected interests on formally equal footing. Groups that were seen as important contributors to democracy, understood as protection against domination, like labor unions, enjoy no special status. Every affected interest gets a seat at the table. Lawyerly premises about what was required to keep the administrative state within the bounds of the rule of law are embodied in the APA. Its enactment of the rule of lawyers is evident both in what it preserves and what it endeavors to change in existing law. So it devotes the brunt of its attention to adjudicative procedure rather than rulemaking, because agencies prior to the 1960s acted primarily through adjudication. And adjudicative procedure had long since been shaped by Supreme Court due process decisions to require intra-agency separation of investigative, prosecutorial, and adjudicative functions. The APA codifies this, thus meeting elite lawyers' demands that agencies function in ways that resembled courts. The APA expressly provides for fact deference, where an agency's findings are supported by substantial evidence. Whether it allows for any deference at all on questions of law, the core of the legal profession's prestige and autonomy, is hotly disputed. Finally, the APA is silent on race and shot through with exclusions that had the effect of impeding the efforts of civil rights advocates. So the APA exempted from its rulemaking requirements all matters related to public property, loans, grants, benefits, or contracts. So most administrative actions continued to be handled informally, to the dismay of racial justice advocates who unsuccessfully, for example, pressed federal housing officials to prevent government funds from being used to build segregated housing, neighborhoods, and schools. This would be of only historical interest if the APA's structure and content did not, as elaborated through administrative common law, continue to cleave closely to the premises that underpinned its initial enactment. But it does. The APA is still a pluralist instrument that does not redress asymmetries of resources and power, still offers formal neutrality that predictably advantages those with more resources and more power, still makes judges and elite lawyers into managers of the administrative state, and it's still an impediment to left efforts to achieve transformative social change. It still empowers lawyers, still makes them managers of administration. It still neglects race. Indeed, it may be making things worse. For example, requiring that final rules be logical outgrowths of proposed rules may discourage agencies from being responsive to public comments. Requiring that agencies respond to significant comments has encouraged industry to swamp agencies with complex technical jargon that is nearly impenetrable to lay people, or agencies, knowing that judicial review will be taken with an eye to those significant comments, to prioritize engagement with those arguments. And finally, requiring that agencies demonstrate that they exercise reasoned discretion on the basis of the administrative record in technocratic terms has led to record generation activity that may have little connection to actual decision-making power, as well as demands for cost-benefit analysis that take as given preferences shaped by an egalitarian political economy. Positively, I argue for a different approach to administrative procedure, one fit for the crises of economic precarity, systemic racial inequality, and environmental destruction that confronts us. What would this approach do? It would focus not on formal participation merely, but on addressing power disparities and building power to affect agency decisions by race and class subjugated groups. It would focus not on technocratic considerations, but rather on fleshing out values that agencies are making and trade-offs that they are making in terms that lay people can understand and contest. It would encourage reviewing courts to allow agencies to state those values directly and enable people to shape their comments in ways that are more likely to influence policy outcomes. Finally, it would expand the concept of expertise in ways that would address the APA's neglect of race and class. Agencies have a host of tools to obtain information from missing stakeholders, but their use of those tools is unsystematic, unstructured, and ad hoc. Requiring agencies to treat comments by race-class subjugated communities that stand to be affected by regulatory decisions as significant would be a positive step forward. And finally, more generally, it would scale back forms of judicial review of agency action that effectively give concentrated interests a second bite at the deregulatory apple. Now, I am not claiming that it was possible for something better to have emerged from the precise conditions in which the APA was framed and ratified. I am not proposing that the APA be interpreted by judges in a way that will promote my vision of democracy. I think that would be wildly anti-democratic and contrary to the rule of law. The history of administrative common law provides little grounds for left-of-center confidence in APA common law. Indeed, APA originalism might actually be a better bet to the extent that it would call into question things like the logical outgrowth rule. I'm not necessarily proposing that the APA be replaced with something else entirely. I think that's a very heavy lift. But I am proposing to think about reforming administrative procedure without undue attachment to the APA. There was, at one point, and resurgent now, a radical, redistributive, power-shifting edge to the New Deal that was dulled by 1964. And there's interest in recovering that today, while recognizing that even at its most radical, the New Deal was very badly limited in race-class stratified ways. Agencies also can do things that aren't required by, but also aren't forbidden by the APA by way of making up for its defects. And as entrenched as the APA is, it has been amended. So, pessimism of the intellect, optimism of the will.
Thank you.
Thank you, Evan. It's such a pleasure to be the most conservative person at the table. It happens so rarely for me. Thank you to Emily and to everybody else for inviting me as a socialist atheist Jew. I've always wanted to come to Notre Dame. I worry what would happen to my soul when I set foot on campus, but I remember that my people don't believe in hell, so it's fine. I also want to say that I've heard some of you might also be socialist atheists, and if you are, this too shall pass. You can always come to New York. Professor Bremer and I have a long-standing agreement. If you can't get the support you need at Notre Dame, you can always talk to her and come talk to me over in the People's Republic of Brooklyn. This is also a dream conference for me, though. I hope the students at the Notre Dame Law Review are very proud of what you've accomplished. It's really quite an achievement and tremendously intellectually exciting. I just want to start with an apology that I didn't circulate a paper in advance, but I promised to make up for it by having a very simple and short paper that makes 3 very obvious points, and then I have a very underwhelming conclusion. So just to preview what I'm going to say, so the puzzle that I'm focused on is a straightforward historical puzzle. We all know that the president is very involved in administrative action, and we also know and have heard a lot today already about how the basic bargain of the legitimacy of the administrative state is to subject administrative action to some form of court review. And yet, and here's the puzzle, it doesn't seem like the Administrative Procedure Act tells us very much about how to review presidential engagement in agency action. We do it, courts do it, but they've had to come up with workarounds to make it happen because the Administrative Procedure Act, this alleged framework statute, super statute, unpleasant outgrowth of the end of reform, doesn't seem to account for this single most important feature of modern administration. So how did this happen, right? How is it that the single most important statute for formalizing court review of administrative action has no provision for the single most significant feature of administrative action today? That is to say, presidential involvement. Or to frame the question another way, what was the place of the presidency in administrative action such that the APA took the form it did? So over the course of the next 15 minutes, I'm going to flesh out this question in a little more detail and suggest an answer. This is the 3 obvious points and the underwhelming conclusion. So obvious point 1, that presidential involvement in administration is something that has grown over time. Obvious point 2, that court review of agency action is central to the legal legitimizing effect of administrative action and the APA in particular. Obvious point 3, that the absence of APA review for presidential involvement in administration points us to a crucial historical insight about the role of the president in administration in the 1930s and 40s. And this takes me to the underwhelming conclusion, to give it away. The president simply was not understood as a threat to administrative rights, but rather, and somewhat counterintuitively, their guarantor. Right? This is not just then about the lost world of administrative law, as Daniel Farber and Anne Joseph O'Connell called it in an important article from 10 years ago. Their lost world is actually just one piece of a whole lost regime, one in which administration itself was fundamentally different. Okay, so point 1, presidential administration is a big deal. We all know this now. This is a story we're very familiar with. The simplest way to think about this, but I think it's wrong, but I'm going to say it anyway, is that the president was once not a major domestic policy actor, and now the presidency is. This is wrong the same way that vulgar Marxism is wrong. It's pretty good at explaining about 85% of what's interesting out there in the world. So if you need to get the general trend of it, you can stick to this, right? Once upon a time, the president did nothing, and now the president does everything. My current favorite example for just how big a shift this is comes from Professor Peter Shane's new book, Democracy's Chief Executive. In the late 1970s, Professor Shane was working in the Carter Administration Office of Legal Counsel, and he got a request for a formal opinion about whether the Secretary of the Interior and the Office of Surface Mining and Reclamation could meet with White House advisors. So I just want to pause this and emphasize it. This is a presidential agency. This is a secretary who serves at the pleasure of the president, and it's somebody within that office. And they want a formal opinion about whether it's even okay for them to go talk to White House advisors as they take administrative action. So the Office of Legal Counsel eventually said it was fine, but the key point for our purposes is that it required a formal opinion at all. Right now, this wouldn't even register as something you would want a formal legal opinion on. But as late as the Carter years, it was not clear that an executive agency beholden to no removal restrictions could actually talk to the White House as it was contemplating administrative action. So how we got from that, that old world, of course, is unrecognizable to us now. We know that the president is involved in every aspect of administrative action today. I'm 36. In my lifetime, every president has sought to realize signature campaign initiatives on which they ran for election through control of administrative action. So, okay, how did we get from that old world, right, the sort of Carter world or the pre-Carter world to the world of today? It's a complicated story. In a forthcoming article, Lev Menand and Ash Ahmed of Columbia Law School and I tease out 3 phases in the growth of presidential administration. We argue that from the 1920s through the 1960s, you should think about Congress and the president working together to build out an apparatus for presidential administration. So this is a statutory phase, right? Think here about the Budget and Accounting Act of 1921, the Executive Reorganization Act of 1939, and of course, the Administrative Procedure Act. But from the 1960s onward, you see the presidency starting to go it alone. And that actually sets the stage for another shift in the legal foundations that the White House relies on for its claims. So to schematize a little bit, at first the president makes a managerial claim. They press a managerial argument founded on information forcing, which maybe references the opinions clause, although it's not clear how much that actually comes up. But by the 1980s, you see a shift to a much more extreme form of constitutional argumentation, founded in the Take Care Clause and the Vesting Clause, has roots in the Ford OLC, but really comes to life after that. That, of course, is the foundation of what is now called the unitary executive theory, and it seems to be the direction the Supreme Court is trending. The key point, which is the boring obvious point, presidential administration once was not a big deal, and now it is a very big deal. So that takes me to point 2, the centrality of judicial review. As the president's role in administration has expanded, the problem of reviewing presidential involvement in agency action has become acute. I do think it's worth taking a second here to review what I understand to be the basic bargain on which the American administrative state was built. Now, there's a standard story that some of your professors, in their well-meaning enthusiasm for European ideas, might be trying to teach you about the incompatibility of European droit administratif with a common law tradition of court-adjudicated rule of law. On this account, the puzzle of American administration was how to introject something basically foreign, this European idea of French droit administratif, into an Anglo-American tradition of common law courts. I think this is wrong. I do not think this is the right way to understand this story. As far as I can tell, it was invented by Albert Van Dicey and other conservative Victorians with dubious ideas about a racialized empire of English-speaking peoples, and they pushed this argument for largely political reasons. I think a better take on what's going on actually comes from new work by Jane Manners, a young legal historian at Temple. To preview her research with her permission, she points out or reminds us that in the 19th century, the way that we tended to oversee administrative action was through something called the law of officers. I asked you a question about this earlier with respect to the law of equity. Under this law of officers, courts would judge individual government officers' behavior for illegality. So if I'm a customs officer or whatever, I take action, I had to put up a huge bond to become an officer in the first place, and if the person I took action against didn't like it, they would sue me, and my defense would be that I acted within the law. And if I lost, I have to forfeit that huge bond I put up to become an officer. The law of officers may or may not have worked well, we can argue about it, but it was not well suited to an era of active government or bureaucratic agency action. So this then sets up a different puzzle, one that's much closer to Emily's example about government inertia being all-conquering, right? How do we reconcile a tradition of court defense of individual rights with a new world of institutional actors when you have to get beyond the law of officers? To tip my hat to Evan, there's a political economy story to this dimension to this story too. In the 19th and 20th century, administration is largely about regulating capital, especially utilities. Professor Family made this point during her presentation as well. In some cases, administration is literally just about regulating the rate of profit on large industries. If that's what's happening to you, you can understand why, if you're a large regulated industry, you have a strong incentive to resist. But of course, those industries are losing power in the legislature and the executive. After all, it's the legislature and the executive that are creating those profit regulating agencies in the first place. So where can they go? Well, they still have power in courts, right? Many of the federal court lawyers were drawn from the very same social class as the regulated industry. If it's the 19th century, the way you get to be a judge is by becoming a railroad lawyer first. So the industries, they turn to the lawyers, not exclusively, they turn to lawyers in general, and judges in particular, in order to make their arguments to protect themselves from what they perceive as this illegitimate assault on their rate of profit. That general dynamic lies behind what, before this talk, we would have called the fierce compromise of the APA. Now that we have the benefit of Evan and John's work, we can call it something else, the deep compromise, the de-radicalization embodied in the APA. But basically, you've got decades of conflict over court review before the APA, and the APA codifies, revises, turns into words some kind of rule of engagement. The way that I see it, at the core of the APA, there are three commitments. The first is separation of functions within agencies. The second is something like reasoned decision-making. But the third one, which eventually becomes the keystone, is limited court review under limited circumstances. It reconciles lawyers to the APA because it gives them jobs. It reassures regulated interests because it puts them in front of a decision maker they can live with. And it integrates the APA on the common law, while the presence of an outside adjudicator guards against what Roscoe Pound dismissively called administrative absolutism. But all is not well in paradise. If judicial review is central to administrative legitimacy and the president directs administration, we have a problem, which takes me to obvious point 3. Why is there no review of presidential involvement in administration under the APA? If you've taken ad law, you know this already, right? The president is not an agency under Fox. This is especially mysterious, the absence of presidential review under the APA, because of the context of production of the APA. After all, the regulated industry is pushing back through the New Deal. We're pushing back in part against, quote, that man in the White House, end quote, the president, Franklin Roosevelt. So this makes the APA's silence on presidential involvement even more puzzling. Okay, one solution, which is a solution proposed by Katie Kovacs, an eminent scholar of the administrative state, is to say that I am wrong, that Fox is wrong, that the Administrative Procedure Act is not silent, and in fact did intend to cover the president. And she has some very strong arguments on that score. I commend her work to you. It's called Avoiding Authoritarianism Under the APA. I won't go into the details except to say that she regrettably doesn't have a smoking gun, although she does get close. And the biggest evidence against her is that there is no precedent to rely on for that proposition, which is especially damning here because, as you heard from Professor Bremer, the APA revised, but it also codified. So it sure would be great if there were some cases in which courts reviewed presidential involvement in agency action that you could point to. Yet as far as I know, there aren't any. And it's not that the courts were shy about reviewing the executive, right? This is the era of Humphrey's executor, of Schechter Poultry, of Panama Refining. The court is only too happy to pull that man in the White House into court and tell him that he done wrong. So what is going on? What do we make of this not barking dog? And this takes me to my promised underwhelming conclusion. Prepare to be underwhelmed. I don't have a great answer. Underwhelming. I have two hypotheses, though. The first is that presidential review of agency action was not a major consideration in the 1930s and 40s. This would explain why it's not a central part of the APA, why it isn't a major part of the pre-APA case law, and it answers a mystery that Kovacs herself alluded to, which is why the president just doesn't seem to be seem to be a major part of the various pre-APA materials that are produced as part of the lead up to the APA. So you may have heard that we are now beneficiaries of an amazing, and I might add prize-winning, compilation of historical documents, the Bremer Kovacs collection. And as you can see, if you review the major documents in there, including the ABA Special Committee on Administrative Law, the AG's report, the hearings on the bill, and the AG's manual, the problem of presidential involvement in agency action doesn't seem to preoccupy folks very much. There is one major document collection that Professor Bremer and Kovacs say they are missing. It's the collection of the President's Committee on Administrative Management. As it happens, that's the only historical source I know anything about. And in that source, too, there isn't a lot of discussion of how the president's involvement in agency action should be subject to court review. In general, we do see a shift in these materials from a hysterical worry about administrative absolutism to a more measured take on promoting reasoned decision-making, but the lack of concern about the president seems pretty big. In historical context, I would say that shouldn't be too surprising. This takes us back to my vulgar line about vulgar Marxism, right? Only 85% right. What about that 15%? What was the president's role in domestic policy making? Well, of course, the president has always had some role, but it was a different role, right? For most of American history, it was just about personnel. The president was involved in staffing, but staffing was a consideration of politics with a small p, right? The way you become president in 19th century America is by lassoing together a bunch of disparate political constituencies and political machines. And then you have to give the people who supported you rewards. The rewards they want are patronage jobs in government. That's what it means to staff the administration. Things are changing in the years before the APA is formulated, though. As the scholars Stephen Skoranek and Karen Oren put it, the domain of policy is expanding. With the New Deal and World War II, the government comes to touch on ever more aspects of life, and the president in turn comes to rely on an army of professionalized civil service administrators to do that action. The president in this new world is much more of an overseer than a decider, because this new state is too complicated and doing too many things. So his major responsibility is still to staff the offices, but he's no longer going to staff them merely with hacks. He's going to staff them with people who share a vision. So this takes me to my second hypothesis, and then I'll conclude that in realizing this effort, the president is working with Congress, not trying to usurp its place. Remember that throughout the 1930s, the Democratic Party has unified control of government. The rise of the conservative coalition will come to undercut things, but it doesn't derail them. The result is that the agency action that the president is pursuing is pursuant to clear congressional delegations and empowerment. Congress is making policy in the regular course and selecting to implement that policy through agencies for its own reason. But no one doubts that Congress could pursue the same policy through other means if it wanted to. And if the president needed more than he could get through the agency, he could just go to Congress and get a bill. He does it all the time. In that world, court review of agency action serves a different purpose than it does today, right? Congress and the president are working hand in glove, so agency action is presumed to embody a shared government commitment, and administrative law is about preventing a certain kind of overreach, right? An overreach that impinges on individual rights. It is not a forum to challenge policy, since that policy is properly set by the President and Congress acting together. Rather, it's about making sure that the implementation of policy does not accidentally trench on court-protected interests. In that project, perhaps oddly to our eyes, the President is an ally of Congress in protecting those interests, since the threat comes not from implementation of the laws, but from their haphazard implementation. So putting all this together brings into focus a very different role for the President in the administrative state. He is not realizing specific policy initiatives through administration. To do that, he goes to Congress and gets a law. When it comes to administration, the President is genuinely implementing Congress's law, pursuant to general priorities he sets, largely through his personnel choices. For that reason, no one is worried about the President substituting his will for Congress. Why would we? Rather than a threat to individual rights, the President, along with the courts, is their protector by ensuring a consistent, centralized, coordinated administrative apparatus. If my hypotheses are correct, they reveal two intriguing things about the Administrative Procedure Act. First, Daniel Farber and Ann Joseph O'Connell were even more right than they knew about the lost world of the Administrative Procedure Act, but we need to see that lost world as itself part of a whole governance regime. Once we recognize that governance regime, we have to recognize that it is gone, it is dead, it is lost, it is never coming back. And that takes me to the second point, right? If that world is behind us, it explains why the original Administrative Procedure Act might simply not be well suited to handling the new administrative challenges of governance today. And so I think it raises the challenge that you saw both Evan and Emily grappling with, which is what should an Administrative Procedure Act 75 years later look like when the government is no longer operating the way it used to. Thank you.
We're not going to let you stop there. We're going to come back to that. No, I'll let you guys sort of bounce off each other's papers if you want to first, and then if not, then I'll jump in with a couple questions and open it up to the group. So.
I have some thoughts. Shockingly. So I'm going to start with Noah, and then I have some thoughts for Evan too. So I agree with some of your hypotheses, Noah. I think one answer to the question that is consistent with what you said, but that maybe adds some more sort of detail, is I think the APA's drafters would have considered the statutory authorities that were given to the President probably to fall mainly into the category of executive action, which was sort of mutually exclusive from administrative action and not what they were regulating. Right, so, and this was something that was not clear to me until a couple of years ago when you read the report of the Attorney General's committee and you realize that like they are saying if it's administrative, it's the powers of federal agencies that affect private parties. And it's by definition not executive, right? They talk about like why Congress would choose to give something to an administrative agency instead of leaving it to executive discretion. Which suggests to me that they view those as sort of mutually exclusive categories. And the authorities that are granted to the President, I think they would have mostly viewed as executive for a variety of reasons, many of them historical, because of the sort of areas in which the President was given statutory authority to do various things. And then in some cases, because it was internal and not about sort of binding private parties outside the executive. So I think that might be part of the answer. And I mean, the research underlying the APA is all research on individual administrative agencies. And of course, the convention has always been, and I'm going to not speak to why it is this way, but Congress historically has given authority to the heads of individual agencies. So for the most part, Congress doesn't give the authority to the President and then allow the President to vest it in whatever department he wants. They give, the Congress has given the authority to the Secretary of Transportation or to the, Federal Communications Commission or what have you. And so I think at least for some time there was an expectation that that authority belonged to the head of that agency and not to the President, in which case, et cetera, et cetera. The other thing I'll say is I totally agree with you that part of this has got to be change, right? And I mean, one of the really fascinating things to me about the sort of so-called shift that we've already heard about from adjudication to rulemaking is that for a long time, presidents tried to get a grip on this unwieldy, decentralized administrative state, but when it's all adjudication, it's all ad hoc, and policy only kind of emerges over time, it's really hard to get a grip on it and direct it the way you want it to go. And so I think it's no accident that it's only in after the 60s and 70s, and we shift to policymaking through rulemaking instead, through the notice and comment process that requires an agency to give notice, advance notice of what it plans to do and take comment before it finalizes rules, that you get an executive structure that allows a more centralized sort of handle on the policymaking apparatus. And you see the notice and comment process replicated in the structure for executive review. So yeah, I mean, exactly. So I'm with you on the change part. And one thing I'll just like footnote, because this ties into the conversation we've had earlier about the major questions doctrine. I'll just throw this out there. You know, one way to understand the major questions doctrine is as a judicial response to a rise of presidential directive rulemaking authority. And then in response to Evan, I just want to, as the person who teaches civil procedure and administrative law and really loves procedure, I just want to make a pitch for neutral principles of procedure really in all institutions. I think there's incredible value in leaving the substance to the substantive law and having principles that govern your decision-making institutions that are drafted in neutral terms to serve what I view as the sort of substantive values of procedure, which are, I think, real and important values, and that should be created neutrally. And part of that is because I think we downplay the significance and the importance of the principles that animate procedural rules in administrative law and in courts and elsewhere. But also, like, we want to have regimes that are durable. And I think neutral principles have a much greater likelihood of being durable without preventing change as society realizes it needs new substantive norms to address emerging problems. And I just, in general, I think we should leave our substantive policymaking to substantive statutes.
Do you want to respond in order, Noah first and then Evan, or?
Yeah, sure. No, this is great. I mean, so Emily and I had a brief conversation about this last night, which inspired me to go back and take another look at the first chapter. And the thing that totally strikes me is that I think there's been this recurring problem, at least in that period, about exactly where to draw the line between executive and administrative. And so I think you're totally right. But as I recall, even in that chapter, they start to recognize that the one can blur into the other. And in the back of my mind, I have this James Hart essay that I found in the great Bremer Kovacs collection, where he's talking about, James Hart was a professor of public administration and administrative law, put together one of the great case books, and he's talking about the need to concentrate power in the executive, building off of a scholar I've spent a lot of time studying, Frank Goodnow, saying that the key to a responsible administration is to have the president with greater supervision over the administrative apparatus. And then he says, the problem is that sometimes, of course, there's executive discretion that's given to the president, and there it's clear that you can't have oversight. And then at the other extreme, you've got what look like ministerial duties, and there it's clear that it shouldn't matter what the president is, but all the stuff is falling somewhere in between. So how do we handle it? How do we regulate it? And my only sort of thought on that score, and I love the point about rulemaking. I think there's probably another point there about information and getting access to it, that it seems pretty clear reading Wilson's papers or looking at the way that Harding ran his government, right, in sort of a post-administrative agency moment, but pre-APA moment, that they have clear policy goals they're trying to achieve, and they're picking subordinates to run their agencies so they think they will do it, and then they really do just let them run the show. And that's kind of how the president realizes policy, and that totally dovetails with the point Professor Bremer made about where discretion is vested. So, before the Budget and Accounting Act of 1921, there isn't centralized procedure to consolidate budget requests from agencies, even executive departments. In other words, if you're the Secretary of the Interior, you could be going right to Congress with your budget request for program funding without even telling the president what's going on, right? Kind of bonkers. So how do you even try to run the government if you're the president there, right? It only works if you have got somebody in Secretary of the Interior who really is your ally, but then they really are running their own show. And so a lot of things need to change, including the creation of a White House staff, changes in information reporting, perhaps also changes in the way administrative action is self-conceptualized to realize this kind of hope of presidential responsibility, which is an active project that people are pushing throughout that moment. So I think I take your conceptual clarification point. I think it's super useful. My guess is that the administrative law nerds of the 1940s would have recognized that worked at the extremes, but not in that middle ground. But that just only makes me more desirous of wanting to grill one of them and be like, okay, my man, so what is this? Is this executive or administrative, and how do you draw the line?
Well, this is exactly why they drew in a bunch of executive agencies into the study, because they realized, well, if this is what we're focusing on, we can't just look at what we have so far thought of as administrative agencies, the ICC, the FCC,
Absolutely,
all those.
right.
Because, oh boy, there's a bunch of executive branch agencies that are in departments that are doing exactly the same stuff.
Totally, no, this is a risk of becoming a super nerd fest, but then you've got,
I think we're well past that point.
Well, then, okay, so then, what do we do about the bureaus, right? Because part of what's so exciting, what they recognize is that you've got things that are acting on the same kind of principles as the independent agencies, which as far as I can tell, like the real defining feature for them in the independent agencies is the commission model. So, but then you have bureaus that are using the kind of expertise of the commission model, even though they're single-headed and they're within executive branch agencies. So just truly like a yes and in the improv move, absolutely, they recognize we can't just use the ICCs of the world, we need to bring these in.
There you go. Go ahead, Evan.
So, quick response to Emily and then a question for Delta. So, my argument isn't so much that neutrality is bad, but that neutrality, or the appearance of neutrality, doesn't always lead to neutrality in practice. So, to take a very extreme case, you can imagine a 50-yard dash in which everybody starts from the same place, has to end at the same place, but somebody has their Achilles tendon cut just before the race. They're starting from the same place, they're following the same process, but one of them is going to lose, predictably, because they're operating from an initial disadvantage. And I would argue that the way in which the notice and comment process operates in practice is in a way that consistently advantages organized, concentrated business interests that, because they start from an initial advantage, will come out in a formally neutral process ahead, even if the process itself doesn't say, we are going to favor concentrated business interests. I mean, this is kind of like, if you want to talk about the vulgar Marxist perspective, or if you want to talk about public choice, there are certain groups that are just going to operate as with an advantage in neutral processes unless you set them up in such a way to ensure neutrality in practice. And that's basically what I'm arguing, that the value of neutrality, the rule of law is, if not an unqualified good, a good. We should preserve it. Informality in the context of adjudication, as you point out, can lead to all sorts of injustices that would be remedied if we had more neutral procedures in places that affect fundamental liberty interests. Absolutely. I just think that we need to be attentive to the possibility that neutrality that's formally presented may not actually be substantively neutral. So, not neutral principles are bad, but just be a little bit careful with them. I'm interested in why you don't buy Katie Kovacs' argument that the president isn't an agency covered by the APA. I like this idea of an internal legal perspective saying that this isn't executive action, or this is executive action, and we're concerned with quasi-legislative and quasi-judicial action in the APA. But what's your theory of the exclusion?
So the best argument, so the Katie has in this great article about avoiding authoritarianism, she's got several arguments for why you should include the president. As I recall, the strongest arguments are that there's the language in the APA is quite broad, that refers to sort of any authority or agency, that there was a concern at the time about fascism or authoritarianism, and so it's really in keeping with the spirit of the APA to allow for that review. And then I think actually her strongest piece of evidence is one that I don't know a court would ever consider, but I think in the AG's manual from 47 about how to implement the APA, there's a reference to the kinds of things, there's a distinction that's made between stuff that could be reviewed and couldn't be reviewed. And I think under one of the things that can be reviewed is like the president's setting of tariffs. Or maybe sorry, let me look at my notes again. But basically there's a suggestion in the manual, which I guess is Clark, right? That one thing that the president does could be and one thing couldn't be. So that feels like strong evidence for why it could. Right? I think the reasons why that probably isn't true are, one, just the precedent issue. The fact that we just don't see any review of the president in courts before with respect to that. And so insofar as the APA is engaged in codification, and I guess count me on the side that says the APA is mostly about turning existing procedures of court review agency action into something that's a little bit more formalized, that's sort of one piece of evidence against it. And then the other is the silence. It's the dog that didn't bark side of the story. And I think I've got a good explanation for why the dog isn't barking, which is sort of building off of Professor Bremer's point, that actually at that point, the discretion and the action is vested in actors below the president. It would have been as strange to pull the committee aside and say, I want a procedure to review presidential involvement in administration, as it would have been to say something like, I want a procedure for reviewing our commitments under NATO or whatever. They would have said, what's NATO? I don't understand why we should review them. I would say, why should we review the president's actions in administration? The president doesn't take that kind of action. They would have said the way the president takes action in administration is by picking his subordinates to serve in those positions, and then we'd have a big fight about removal for cause or not, and whether the positions could or could not be defined by Congress to include various removal protections. So that's my pitch. I don't know if you're persuaded.
Well, I mean, I feel compelled to point out that I have a very large dog that would probably not bark if a burglar came in armed with a machine gun. So, like, as far as the generalizations go about dogs, I mean, I feel compelled to object. But no, that's a very good explanation.
All right, let me open it up to the audience here for questions. Go ahead.
So this question for Emily, for an observation. Let me offer a counter hypothesis as to why the adjudication model failed, which I believe many administrative law professors would subscribe to, which is they just don't think that the APA type model is well suited to the range of tasks that agencies now perform. They just don't believe that a trial type hearing or an ALJ, separation of functions and the like, is suitable for this purpose. It's not because of the mixture, it's not because Congress didn't adapt it, and not because of inertia, they just think inept. And I'm sort of have in mind a sort of comparison with the Matthews revolution of constitutional law, where people believe for a long time that the trial type model was the model. Goldberg said that, and then you have a reaction against it, and Powell says, no, that's too extreme, and so after Matthews, there's a shift really to that model. Now, I know that is not what you believe, but let me complete my thought. I think that view is widespread enough that you should address it. And I know that the latter pages of your rediscovered stages piece makes the case that really this model is more adaptable than many people suppose. I think you should put something like that in instead of just taking it for granted that the APA model could work in a wide range of situations. You should say, well, maybe some people don't believe that, but I do for the following reasons. And maybe that I think that would come across more persuasively if you didn't just take it on faith, but rather try to address what is probably, in some people's minds, a reason to think why it will fail, and then say, in my view, maybe you're being too negative.
Yeah, so I hear in your comments actually sort of two propositions. One is a descriptive proposition about the extent to which people sort of were persuaded that the APA's compromise was a good compromise. And then the kind of more merits-based question of, like, was it a good compromise? Like, is it workable? And running through the essay, and I don't think I emphasized this, I entirely agree that the major reason why the APA's adjudication provisions failed is because people, we talk about the APA as a grand compromise on which these hard-fought contentions came to rest. I don't think that's true. I don't think they actually persuaded people that this hearing regime is a good hearing regime that should apply anytime that there's an adjudicatory hearing. And it started to fall apart immediately, and it just unwound over time. And there were lots of things in the system that allowed that, I think, latent disagreement with the APA structure to take root and to spread. But on the merits question, I think you're entirely right. Like, so far, what I've done is try to understand what the APA means. And then the question is, well, if it has failed, or if it is, because I don't think it's totally failed yet. I think it's mostly it's like Princess Bride. It's like mostly dead is not all dead, right? And the next paper is an argument for why we should bring it back to life, because I do think it's underestimated the extent to which it is flexible for a wide variety of hearing programs. And I think you're absolutely right on the Matthews versus Eldridge, that we have shifted since the APA was adopted to a kind of individual rights model of due process to a managerial approach to due process that is fundamentally different and sort of inconsistent with the APA structure. And I actually would defend the APA structure. I think it has important protections for impartiality, for competence of adjudicators, something that I think gets radically downplayed, and is consistent, contrary to some of the suggestions in recent Supreme Court decisions, with the president's obligation to ensure that the laws are faithfully executed in adjudication. Right? It has agency head review, it has protections, it has independence. I think it's a good regime, and a better regime than we have in many hearing programs, perhaps most critically immigration is the great example of like everything that goes wrong when you just throw all of that out the window.
Go ahead, Chris.
So I kind of asked the question I was going to ask, but I'm still going to ask it, because I kind of looked at the story, and this is, and I'm going to feel fortunate to say this, I've done a lot on education, but I mean, it's the mass adjudication story, a big part of this too. In other words, switching from, during the APA, we thought about education with Canadian policy, private right, we were thinking, and now we're thinking hundreds of millions of cases a year. Some are quite low dollar, whether it's veterans or Social Security. I mean, is there a story? Is that part of the story? Like the APA was envisioned for a different time.
I don't agree with that, actually.
Yeah.
No, I mean, now I think a lot of the focus was on economic regulation and on the ICC. The Social Security Board was one of the agencies that the Attorney General's Committee examines, and it seems very clear. I mean, the hearing requirement in Social Security was added in, I want to say, 1935, right before the Attorney General's Committee was studying this, and before, of course, the APA was adopted. And everybody, the strong impression I got from reading that study is that everyone sort of assumed, okay, this is a hearing requirement we're adding as a last stage on top of the regime we already have, and whatever ends up being regulated in the APA as hearing provisions, that's what we'll adhere to. That's because it'll apply to this. And that's what descriptively, that's what Social Security did immediately. They have always used ALJs. They fought some very high-level political battles internally within the administration to get ALJs appointed when the disability program was created later, for example. And all of that was based on an interpretation of their statute that this is a hearing and therefore it's regulated by the APA. And I think everyone agreed with that until very recently. In large part because we sort of lost our clarity about what the APA's adjudication structure is supposed to look like. And that is a high volume program. And I think it's probably better than it would be if the APA's procedures and ALJs had not been used. You just hire more ALJs. I mean, they said that like the Attorney General Clark in his message supporting the APA's adoption says, this is going to be really expensive because agencies are going to have to hire a bunch of, we didn't call them ALJs then, but they're going to have to hire a bunch of ALJs. And it's like, yes. And so they did in some programs. And they got out of it in immigration, right, for I think other reasons. But no, I think they were trying to create principles that were cross-cutting across, and I don't think they were just thinking about the ICC.
We have time for one more. Well, if not, then I'll ask it because Noah, I said I wasn't going to let you leave it there. We have this whole thing from Justice Kavanaugh where we're supposed to live on the east side of the mountain, be looking toward tomorrow and not looking back toward, So, I mean, you kind of left me wanting more. You said, oh, what are we going to do about this? Well, what are we going to do about this,
So I feel conflicted because I also, live on the east side of the mountain. I'm very optimistic.
Yeah.
And so I'm torn in two different directions. So let me just lay out the two visions, right? There's a positive vision. I went to Deep Springs College, which is this 2-year college on a cattle ranch that's self-governing. And so I really believe in small d democracy. So there is one world in which we are able to self-organize as citizens in order to realize the latent possibilities of democratic self-government and use that to try to reorganize our state and federal governments in a way to really give voice to what it is that people want. And that's like a really tall order, but I really do believe it's possible. And that's really exciting to me. But there are, as Evan has sort of alluded to, a whole series of really devastating challenges facing this country. And the last 20 years, I'm 36, I've been politically conscious for 25 years or so, right? Not that I was conscious, 11 I can remember things. But in that time, the key point is just to stress that across that entire period, what we might think of as the traditional way in which American government was supposed to operate doesn't really look. So I tell my students in leg reg that they were all taught a lie with that how the bill becomes a law thing, right? It's much better to think about governance as a project in which somebody is elected to be president of the United States, a large media focus bears down on their policy, and then they use the small tools that they have at their disposal for about 2 of 8 years to try to ram through an agenda as quickly as possible to address a whole bunch of crises while avoiding nuclear warfare and all that. And if that's the real form of government, right, okay, one last piece and then I'll just on this, which is Augustus, when he took over the Roman Empire, it was said of him that he kept the name of the republic and its forms while changing everything about it. Right? And so if you're going to move into a world in which you have a single imperial leader, but the form of a republic, the classical traditions of political thought would tell us you can still distinguish between good government and bad government, but the line of distinction looks really different. So the optimistic Noah, the small d democratic Noah says, we can still do it. We can have a democracy, but we probably have to abolish the Senate. Like, we have to do major changes. We have to do serious thinking on a level that, frankly, nobody in at least 2 generations has engaged in. Do I think we're up to it? I sure hope so. History is not on our side, though. History suggests that, as with this wheel of empire, right, we are turning towards a more imperial regime. And in that case, I wonder if the challenge of law schools is, in fact, to articulate what does good government look like for something that is a republic in name only. And the answer to that, actually, like, there's a real challenge for law professors there. We have to start looking back towards Tacitus. It's a very different project. Administrative law has a central role to play there. But it probably involves formulating a law that is adequate to imperial executive control of administration rather than Evan or my small d democratic dreams.
What a perfect note to end on, and turn it over.
I was all in Schoolhouse Rock.
Thank you everyone for coming. I just wanted to say a few quick thank yous before letting y'all leave. First, I wanted to say thank you to Professor Bremer. This wonderful symposium started out just as a rumor I heard last spring that my awesome admin law professor may just have a proposal for us for the law review to have a symposium here on the Administrative Procedure Act. And I'm really glad that it came into fruition. I want to thank Nicholas, the EIC. Thank you for all of your help putting this together. Thank you to Joseph Graziano for conducting all the communication with our amazing authors. Thank you to all of our authors for coming out to South Bend January 23rd. We were taking a little bit of a gamble on the South Bend winter, but I think it all turned out really well. So thank you again. I'm really proud of how the symposium all turned out, and I hope you have a wonderful evening.